Welcome back to the afternoon session of the Colorado Oil and Gas Conservation Commission. My name is Jeff Robbins, Chair of the Commission. We have our commissioners with us, and we are getting started this afternoon with a continuation of testimony from party stakeholders on the 400 series rules, which is the subject of today's rulemaking. At this time, Hearings Officer Larson, I believe that we have the presentation of the public water suppliers. So if we could bring them into the house, we will get them teed up for their 38-minute and 15-second presentation.
Okay, we will. Good afternoon, Commission. My name is Stacy Brownhill, and I will be speaking first for the public water suppliers. Then I'm going to introduce our 4 expert witnesses. The public water suppliers plan to use all of our remaining time today on the 400 series, including the 6 minutes donated by Commerce City. We anticipate our presentation will be 44 minutes and 15 seconds. So I'll go ahead and start. I appear today on behalf of East Cherry Creek Valley Water and Sanitation District and Arapahoe County Water and Wastewater Authority. Give me a second, I'm going to share my screen. So I'm speaking today with the support of the public water suppliers. We're a group of 12 parties, and besides my clients, we include Aurora Water, City of Brighton, City of Commerce City, Great Rock North Water and Sanitation District, South Adams County Water and Sanitation District, South Beebe Draw Metropolitan District, South Metro Water Supply Authority, Town of Castle Rock, Town of Loch Buoy, and United Water and Sanitation District. So together, these 12 public water supplier parties worked to narrow down the issues we cared about in the 300 series and 400 series. We submitted joint pre-hearing statements, responses, and witness testimony. And one thing we all have in common is we all depend heavily on groundwater supply. So you'll see that the theme of our concerns is protection for municipal groundwater and aquifers. So today we'll be presenting about the changes we support and the changes we would still like to see in Rule 411 regarding public water system protection. So I'll start with our request that we were really happy to see added in the latest draft rules. The latest draft rules added protection for wells completed into a Type 3 aquifer, in addition to the protection in previous drafts for groundwater under the direct influence of surface water wells, or Goody wells. You'll hear more in a minute about why Type 3 wells are different from Goody wells and equally deserving of that protection. Part of that protection for Type 3 wells includes a 1,000-foot setback, which we appreciate and we believe is important. And so these are changes we support and we hope to see in the final rules. We want to take a second to acknowledge the COGCC staff for all of your hard work with Rule 411. Thank you, we really appreciate it, and we think that these are excellent changes. So I'll turn to the 3 changes we would still like to see. And we submitted a red line of proposed language to staff earlier this week. First, we'd like to see protection for public water system recharge facilities. So briefly, recharge facilities are engineered depressions in the ground that water can be delivered to through ditches or pipes, and then the water seeps into the alluvial aquifer. Public water systems use recharge facilities to recharge or augment aquifers that get depleted from our water supply wells. We're required to do this pursuant to the terms of water court decrees and state law. And the water that we put back into recharge facilities must be of the same quality and quantity as the water that we pump out through wells. Recharge facilities are susceptible to oil and gas spills in that they provide a direct conduit to the alluvial aquifer if a spill were to occur at or near the recharge structure. So for this reason, we would like to see the same protection for recharge facilities as provided for type 3 alluvial wells. Here briefly is just a snapshot of our proposed language. We propose placing recharge facility protection in Rule 411C, where type 3 well protection is currently located. And we want to say up front that we recognize the need to map these recharge facilities. Our engineers have been working on that with the Division of Water Resources. And based on our conversations, we feel confident that this mapping is doable and that the universe of recharge facilities is finite. So our second request is we would like to see type 3 wells treated equally as Goody wells. And in our red line for this change, we simply propose moving type 3 aquifer wells up from Rule 411C into the Goody section in Rule 411B. So under the latest draft rules, type 3 wells are offered lesser protections than Goody wells. For example, operators cannot conduct any new surface disturbance within the internal buffer zone for a Goody well. Meanwhile, they can't construct any new working pad surface within the internal buffer zone of a type 3 well. Operators within 1,500 feet of a Goody well face lined berm, daily inspection, and pitless system requirements. Operators within 1,500 feet of a type 3 well do not. And you'll hear more about this in a minute, but we don't feel that these discrepancies in protections are logical because non-Goody type 3 wells are often shallower than Goody wells and can be just as vulnerable, if not more so. Our third request is that we propose a change to the definition of classified water supply segment to make it consistent with Water Quality Control Commission's Regulation 31. So right now, as proposed by staff, classified water supply segment is defined as perennial or intermittent streams, which are surface waters classified as being suitable or intended to become suitable for potable water supplies by the Colorado Water Quality Control Commission. So this definition would exclude ephemeral streams, but the Water Quality Control Commission does not differentiate between intermittent, perennial, or ephemeral streams when classifying a stream as suitable for potable water supply. COGC staff hasn't provided any basis for removing protections for ephemeral streams that have been classified by CDPHE as being suitable. So we propose removing the type of stream from the classified water supply segment definition, which would make it consistent with Water Quality Control Commission's Regulation 31. So our witnesses are going to go into more detail on these requests. I'm going to stop sharing my screen and go ahead and introduce our 4 experts today. So Christopher Sanchez is a professional geologist. He's president of BBA Water Consultants, and he's here today on behalf of the town of Loch Buoy and Great Rock North. Mr. Sanchez has more than 25 years of hydrogeology experience. Next, you'll hear from Scott Mefford. He's a professional geologist and president of Hydrokinetics. He's here today on behalf of ECCV, Aqua, and United. Mr. Mefford has 40 years of geology experience. Heather Justice is a professional geologist here today on behalf of the town of Castle Rock. Ms. Justice has 22 years of hydrogeology experience. And finally, Scott Niebuhr is the operations manager and a certified Class A water treatment operator here today on behalf of ECCV and Aqua. Mr. Niebuhr has 25 years of water treatment experience. So now I'll turn it over to Mr. Sanchez.
Thank you, Stacy. Again, my name is Chris Sanchez. I work with BBA Water Consultants and have been working on groundwater supplies in Colorado for more than 25 years. I'm here today speaking on behalf of Great Rock North Water and Sanitation District and the town of Loch Buoy. These entities are located in the Box Elder Creek and the BB Draw basins respectively, both tributaries of the South Platte River. And I will be providing some introductory information regarding alluvial aquifers with a focus on some discussion on type 3 wells and how they differ from Goody wells and why that's important. I will now share my screen. First, regarding alluvial wells, I want to provide some description as to what these really are. When the historical stream systems have flowed off of the Colorado mountains, both to the east and to the west, two important things have occurred. One, those streams have carved channels into the bedrock over which they flowed, and those streams have deposited sand and gravel material as well as clay in horizontal layers in those channels that they have carved out. Those sediments are saturated with shallow groundwater, and in the sand and gravel layers in particular, the water is transmitted very readily, and these systems comprise very productive aquifer systems, some of the most productive in the state. Water supply wells in these alluvial aquifers yield anywhere from 250 to 2,000 or more gallons per minute. It's a pretty productive system, and that is why they have been developed significantly by municipalities for public water supply. The map that I'm showing here is the productive portion of the South Platte River from roughly Weld County all the way down to Sterling. Just notice that the aquifer does coincide with the channel of the South Platte River. And then what I want to point out in these cross sections is the channelized nature of the aquifers where the river has carved them out and the systems have filled with sediments, these very productive sediments. In Colorado, well depths can be as deep as 200 feet, but typically we're dealing with well depths on the order of, say, 35 to 100 feet. And that's important. The shallow nature of the aquifers and the water supply wells completed in those aquifers is meaningful because there's greater potential and propensity for contamination to occur to those systems. There's not that much separating the actual aquifer systems from either surface streams or surface influences. This map shows the locations of the alluvial aquifers throughout the state. They primarily occur in the South Platte Basin and the Arkansas River Basin on the eastern side of the Continental Divide. The aquifer systems are pretty thick on the eastern slope, and that's where they have been primarily developed for municipal water supply. On the western slope, the aquifers are not as thick, and there is more abundant surface water supply that municipalities have sought to develop for their municipal supply. And that's really the reason I think we see the bulk of this groundwater usage more on the eastern slope than we do on the western slope. Surface and groundwater interaction is important to recognize as part of this discussion. In this diagram, the unconfined aquifer is an example of an alluvial aquifer. The well here could be a Goody well or a type 3 well that's pumping from the aquifer. It induces groundwater flow towards that well. In this particular example, the stream system is gaining, meaning that the stream gains water from the alluvial aquifer system. The aquifer system is primarily recharged in this example from this area here, where water works its way downward vertically, and that could be from precipitation recharge, that could be from irrigation return flow, or that could be perhaps from recharge from a man-made recharge structure that delivers water to this aquifer system. All of these components result in water flowing toward the stream and towards the well in that particular example. But the opposite can be true. You could also have a losing stream condition in which water is moving from the stream into an aquifer, and frankly, the characteristics of gaining versus losing conditions can change as you move up and down a stream. But the takeaway message here is there's a lot of communication between the stream and the aquifer system. And that's meaningful both in terms of water quantity as well as water quality. Contaminants in a stream system can enter an aquifer, and contaminants in an aquifer can enter a stream system, and vice versa, and both can work their way towards a well. Also depicted in this drawing are these confined aquifer systems. Those could be indicative of, say, the Arapahoe and the Laramie Fox Hills aquifers of the Denver Basin. Those are not the subject of this particular rulemaking proceeding, but it is important to recognize that those are important groundwater supplies as well. Type 3 wells are defined in the well construction rules as, well, and really it's a type 3 aquifer. So a type 3 aquifer is an aquifer that consists of unconsolidated geologic material, including alluvium, colluvial, or unconsolidated materials. Type 3 aquifers may contain localized impermeable layers that do not act as hydraulic boundaries between distinct aquifers. A common example of a type 3 aquifer is an alluvial aquifer. What I want to point out here is that that is a very inclusive definition. It includes pretty much all alluvial wells. It also includes wells constructed in, say, terrace deposits or colluvial material where PWS water supply wells have been developed, but it's more than just alluvium, and it's more than just wells that are classified as Goody. Now, Goody wells, in contrast, are wells that are classified based on the quality of the water produced from those wells. It's a classification based on whether or not it may have microbes, and it's a classification based on whether or not you may see surface water influences in terms of temperature or water quality, suggesting a connection between a stream and the well itself. But that classification doesn't really tell us that much about a well's susceptibility to contamination from a spill. That could be a spill to a stream system involving a contaminant that migrates more readily than, say, a microbe such as Giardia or something of that nature. But also it's important to consider that you may have a contamination event that's removed from the stream system. In this situation, if we had a contamination event close to the well, but far from the stream, this type 3 well is still going to be very susceptible to that contamination event, even though it's not classified as Goody. That's just one example. In my professional opinion, it's appropriate for these type 3 wells to be subject to the same protections that Goody wells are provided. Want to speak quantitatively about the difference between type 3 and Goody wells. We worked with the DWR, and they were generous enough to work with the Water Quality Control Division data set to provide us a reasonable estimate of the number of type 3 alluvial PWS wells in the state. And through their data review, they determined that approximately 164 alluvial wells exist overlying oil and gas basins in the state. 164, that's not that big of a number. But of that 164, 114 of those, or 70% of those wells, are not classified as Goody. Only 50 of those wells, or 30%, are classified as Goody. I want to emphasize this point because by focusing on Goody wells for more meaningful protections, you're effectively excluding 70% of those alluvial wells from the most robust protections under the rules. Finally, want to comment on the data availability and administrability of type 3 wells. The information is available to make it an efficient process for a technical professional to identify type 3 wells using the Division of Water Resource database. That's not an onerous task to accomplish. And furthermore, the Water Quality Control Division has a map of the Goody wells that they've been helpful in working with in terms of making the information on those wells available to us in industry. And the point being that the tools are in place and the data sets are in place to identify these wells, and they are administrable and not too difficult to identify. Furthermore, as time goes on, the state engineer's office will now be requiring well drillers for water supply wells to report the type of well on their well construction and test reports. So the data set available to identify type 3 wells is only going to improve with time. And that concludes my testimony. I will stop sharing my screen and I will hand things over to my colleague, Scott Mefford.
Okay, thank you, Chris. Let me see if I can share my screen to start with here. We appreciate this opportunity to speak with the Commission this afternoon. Again, my name is Scott Mefford. I am the president of Hydrokinetics, Inc., which is a groundwater engineering firm. I am a certified professional geologist, and I've worked in Colorado and green groundwater for about 45 years. I'm here today representing 3 special districts that rely heavily on groundwater derived from shallow aquifer systems. These being the East Cherry Creek Valley Water and Sanitation District, the Arapahoe County Water and Wastewater Authority, and the United Water and Sanitation District. Chris Sanchez has talked in general terms about many of the important facilities public water supply systems, and especially groundwater-based public water supply systems, believe are important to protect. And I would like to extend this discussion a little bit now with specific examples of some of these structures as they exist within the East Cherry Creek Aqua United, or the EAU well field as it's known.
Scott, I just,
Yeah.
We are not seeing your screen, so I just wanted to make sure that you were aware of that.
Oh, okay. Let me see what's wrong.
Could we pause just for a minute, our time?
Yeah, we're
Thank you.
paused.
Let me see here. Let me try and share this again. Is that coming through?
That's better. It's not in slideshow mode.
No, I can put it in that. Let me try that. How about that?
There you go.
That's
Okay.
perfect.
Continuing on, this testimony is presented in support of the concepts delineated in the August 17th draft of the 400 series rules. We believe there's a lot of benefits in those rules and a lot of things that will help out districts like ours. In addition, we would like to describe additional facilities, specifically the recharge structures that we believe are appropriate to protect. East Cherry Creek Valley and Aqua, their districts are located in Arapahoe and Douglas counties, southeast of Cherry Creek Reservoir. And these districts have historically relied upon non-tributary groundwaters, deep aquifer waters, to serve their customers. But as the water levels in these deep aquifers have declined, they've sought additional and renewable water supply sources. And the source that these districts now are primarily relying upon is a unique alluvial aquifer system that lies north of Bar Lake and extends north toward the South Platte River. This aquifer is generally known as the BB Draw aquifer system and is composed of shallow and highly permeable gravels that lie in an abandoned channel of the ancestral South Platte River. The ECCV and Aqua have partnered with United Water and San to develop an extraterritorial well field, or a satellite well field, in BB Draw, and are now pumping this renewable water nearly 40 miles south to their service areas. So this is a really key element of these districts' ability to serve now. The EAU well field is composed of 17 shallow type 3 wells, currently non-Goody alluvial wells. The field also includes 2 large-scale aquifer recharge structures, a very large RO treatment facility that Scott Niebuhr will discuss, 2 11,000-foot deep RO brine injection wells, and 40 miles of delivery main. The overall project is valued at approximately $200 million and serves about 100,000 people in the southeast corridor. The whole project is structured around numerous decrees issued by the Division I Water Court dating back approximately 20 years. EAU has recognized for a long time the potential for contamination of this shallow aquifer. So to help protect the aquifer, EAU has recently completed a source water assessment and protection plan for the BB Draw well field. This study followed the guidance documents prepared by EPA and is administered by CDPHE. And this plan, among other things, identifies potential sources of contamination, plots likely contaminant flow paths to the district's wells and recharge facilities, and proposes BMPs, best management practices, to help mitigate potential contamination incidents. And we see these Series 400 rules as another element in our efforts to protect the aquifer. Among the studies completed for this SWAP plan was a finite difference groundwater model, which predicts the travel times and the flow paths that contaminants would take if spills occurred at different locations within our basin. The yellow area here identifies the envelope in which, if a contaminant release were to occur, that contaminant would eventually reach our facilities. It's important to note here that we're not proposing protective rules to cover this full wellhead protection area, full wellhead, the yellow area. We do believe that the travel times modeled here provide justification for the protections currently described in the August 17th Series 400 rules protecting type 3 wells. Furthermore, this demonstrates that the risk of contamination reaching a well is not really a function of whether or not it's a Goody well, but really it's a simple matter of Darcy's law. In other words, it's a function of the hydraulic conductivity of the formation, the distance between the spill and the well, or the spill and the recharge facility, the porosity of the aquifer. As I indicated, the EAU facility currently has 17 type 3 wells, generally less than 80 feet in total depth, with water tables being 6 to 10 feet. So it's a pretty shallow system. These wells yield from 500 to over 2,000 gallons a minute each from the coarse gravels in the paleo channel of the South Platte. Chris has described pretty well the mechanics of the type 3 wells in some detail, so I won't reiterate that testimony, but I would like to focus on our engineered recharge structures because these are our key element of our facilities. Pursuant to our Division I Water Court decree, we are required to recharge the aquifer in order to pump our full allotted appropriations. This recharge is necessary not only to conform with the requirements of the decree, but it's physically necessary to maintain our well production. We're interested in protecting our recharge facilities, and I'll note that these are very specific engineered facilities we're discussing. These are not broad or poorly defined areas overlying the aquifer. These are very site-specific, area-limited engineered facilities. Our recharge basins look somewhat like the recharge basin that we have here on this diagram. Water goes into the basin, it seeps down into the unconfined aquifer, and then we have nearby extraction wells which pull this water back out and deliver it to the reverse osmosis treatment plant. Most basins work something like this, but ours work actually a little bit differently. In BB Draw, due to the shallow water table and the shallow aquifer materials, the pond base is excavated directly into the alluvial aquifer materials. There's no flow through soils or through an unsaturated zone under the pond, but water from the pond is directly and immediately injected into the aquifer. As a result, any contamination reaching this facility by overland flow or by contamination reaching our facility through feeder ditches or through migration in the shallow native soils will immediately be injected into the aquifer. We can see on the diagram, the water table sometimes in these facilities is maintained above the gravel. Sometimes the water table is maintained below the gravel in order to minimize evaporative losses. But whatever gets into this pond is immediately injected into the deep aquifer system. This is an aerial photograph of the construction of the DeSanti recharge facility, which is one of our 2 recharge basins. And I wanted to provide some perspective on the size and the extent of these facilities and what's at risk if they become contaminated. To construct these facilities, first the area has to be dewatered. Then excavators dig through the overlying materials into the aquifer itself. And we can see the excavators in this end of the cell digging down. Finally, the excavation is completed and backfilled with engineered gravels, and the exposed sides of the ponds are fitted with a synthetic liner to prevent erosion of the ponds and banks. So these are very large and very expensive facilities, but they're crucial to the success of the operation of our well field. When they're done, they look something like this. Again, they're a large and well-secured facility. This facility now is currently recharging the alluvial aquifer at a rate of about 5 CFS, 5 cubic feet per second. Consists of 3 ponds, an initial settling pond, and 2 long parallel recharge basins. And it also consists of, or contains 2 large diameter alluvial recharge wells. So, in summary, the single most important takeaway from this discussion is that the recharge facilities such as these provide a direct and immediate pathway for contamination to reach the aquifer. And as such are critically important, we believe, to protect from contamination. These basins are, in many ways, the foundation of the EAU well field. And these are the facilities that allow the rest of the wells in the field to operate. We believe that such facilities are relatively few in number throughout the state. And with a few adaptations, it would be relatively easy to identify these PWS recharge facilities on the state engineer's GIS mapping. Because these recharge facilities transmit surface water directly into the groundwater aquifer, we recommend treating these recharge facilities in the same manner as a type 3 well under the Series 400 regulations. With that, I will unshare my screen and see if we can do this. And let Heather discuss Castle Rock's work.
Good afternoon. I would like to share my screen, and I just wanted to check on our time as well.
Ms. Larson, can you give us a time allocation?
Yes, you've used 28 minutes and 46 seconds.
Thank you. Thank you, Scott. Good afternoon. First, I'd like to acknowledge and express gratitude to COGCC staff on their continued work on addressing PWS water concerns. I am Heather Justice. I'm currently a Water Resources Project Manager for Castle Rock Water, Town of Castle Rock. I am a registered professional geologist, and I have worked as a hydrogeologist for Castle Rock Water since 2014. Before that, I worked for Leonard Rice Engineers as a project manager and project hydrogeologist. I am testifying on behalf of Castle Rock Water and the Public Water Suppliers Group. The town of Castle Rock currently serves 74,000 customers, which equates to approximately 9,000 acre feet of water annually. And we meet this demand using our local supplies. The town projects that we will have over 1,000 customers by 2030, which equates to approximately 18,750 acre feet annually. Local supplies will not be able to meet our demands, so the town bought a farm. We bought a farm on the Box Elder Creek in Weld County, and at this farm we plan to construct a municipal well field, recharge ponds, and surface water intake. In addition, the town purchased water in the Lost Creek designated basin. The town's Plum Creek, Cherry Creek, Box Elder Creek, and Lost Creek wells are all type 3 aquifers that could potentially be classified as Goody wells depending on if the little bug shows up. Now I'm showing you a map of the town of Castle Rock. The black area shows the current service area, and the purple dots are the town's type 3 alluvial groundwater wells, and the red dots are the oil and gas wells near the town. This next screen shows you the town of Castle Rock's Box Elder Creek farm in Box Elder in Weld County. The black outlines the farm. The purple are the proposed and existing municipal wells and recharge facilities. The surface water intake is not shown on this map, and the red dots are oil and gas wells near the facility. This next map shows the town's type 3 groundwater aquifer wells in the Lost Creek designated basin in purple, and then the red dots show the oil and gas wells nearby. The towns appreciate staff's revisions to the proposed rules to protect type 3 aquifer wells. And now I would like to switch my attention to setbacks. COGCC has offered protection for type 3 aquifer wells by revising the proposed rules to impose a 1,000-foot setback between the pad surfaces and 1,500-foot setback for use of specific fracking fluids from type 3 aquifer wells. The town thanks COGCC for making these important changes. Yet there has been some industry groups who have challenged the setbacks, stating that there is no basis for the proposed setback distances. However, the town of Castle Rock has specific information from its Box Elder Creek project that shows that the setbacks and monitoring requirements are minimum to protect public water supply. The setbacks allow the town the time needed to implement emergency shutdowns so that spills can be contained and remediated, and potentially not spread through the pumping of our wells and the operations of our recharge ponds. The town's mod flow model of the Box Elder Creek alluvium at the existing and proposed wells and recharge ponds is based on site-specific data and is calibrated. This means that this model is real. It is not made up or based on theory. For the purpose of this hearing, we use the model to determine capture areas over time. Most importantly, it shows why 1,000-foot setbacks and monitoring are important to protect the public water supply. The next series of figures will show the capture zone and travel time for non-sorbing dissolved contaminants at our well 14. The figures show two pumping scenarios that are realistic for the town of Castle Rock operating well fields. The model runs the area irrigation wells and ditches are running seasonally. The red lines show the advective capture zone. The black arrows show the travel distance in 10 days. So each one of these arrows is equivalent to 10 days. This first, okay, and the blue contour lines shows our water table in mean sea level. This first scenario, our town well is pumping 260 gallons per minute. It shows that our capture zone is 900 feet in width, and in the distance of 1,100 feet, the travel time is just over 80 days. In this next scenario, we are pumping the well at 390 gallons per minute. As expected, we see that the capture zone spreads over a larger distance and the travel time does shorten. The capture zone width expands to 1,360 days, and over that same distance of 1,100 feet, our travel time shortens to just over 60 days. This shows that without the setbacks from the town's wells, the town would capture the spill or leak in its municipal well more quickly than what we can respond to. This study shows the links in the stability of groundwater plumes resulting from leaks from thousands of underground storage tanks in the United States from gasoline fuel reserves. This report shows that at least 10% of the measured and reported plumes are longer than 700 feet to 1,000 feet. This study summarizes information for 4 separate multi-site plume studies. The study suggests that 2% of the surveyed BTEX plumes are more than 900 feet long. However, a public water supply entity cannot bank on a 2% chance that a spill that is less than 1,000 feet away would not impact the water supply. This study suggests that BTEX was not a conservative proxy for the travel contaminants from a crude oil spills. All 3 studies suggest that there is still a lot to be learned about the nature of the different type of spills or leaks and how plumes spread. Overall, the 3 studies suggest that there is potential risk of plumes exceeding 900 feet. The town needs to be able to evaluate risk of contamination for a well implement the precautionary shutdowns of a water supply and switch to alternative supplies if available. Moreover, we need to determine what additional treatment would be needed on the water supply and if we even have the capabilities to implement the additional treatments. On another note, as a groundwater well field operates, the drawdown cone in the area of influence expands over time. The Box Elder Creek Project well field is planned as a base load well field, meaning that the pumping will occur over long periods of time and the cone will expand and the area of affluence and capture area will increase. This leaves the town's public water supply vulnerable to spills and leaks that are further away than 1,000 feet. However, we have seen that in these case studies and common practice, it helps to have setbacks and monitoring in place for early detection. I'd now like to switch some time over to CDPHE stream classifications. The public water providers asked the COGCC to include protections for ephemeral streams in addition to perennial and intermittent streams. The latest version of the proposed rules did not include that change, which leaves the town and other water providers vulnerable. The staff's proposed rules only protects perennial or intermittent streams that have been classified by CDPHE as being potential drinking water supply. This would, by implication, remove any protections for ephemeral streams classified by CDPHE. In the statement of basis, the purpose, staff seems to imply that COGCC is making a distinction because CDPHE makes a distinction in its definitions. However, it is our understanding that the CDPHE's classification of surface water is being suitable or intended to become suitable for water supplies can include any type of stream, including ephemeral. As a result, the public water suppliers, including the town, would like COGCC to consider the slight change in the definition of a classified water supply segment by striking the words perennial or intermittent streams, which are, and our proposed definition would be, classified water supply segment shall mean surface waters classified as being suitable or intended to become suitable for potable water supplies by the Colorado Water Quality Control Commission. It is my opinion that staff has no basis for removing ephemeral streams from surface waters classified as being suitable or intended to become suitable for potable water supplies. The key is that CDPHE has classified a stream segment as being suitable or intended to become suitable for potable water supplies. Moreover, the rule is unclear about how or who would determine that the stream is perennial, intermittent, or ephemeral, such that a classified stream segment would lose the protection granted by CDPH under this rule. For example, at the Box Elder Creek Farm, depending on what agency you're talking to, that stream could be perennial, intermittent, or ephemeral. So who's going to decide and how are they going to decide? Ephemeral streams are connected and do provide water supply to the public water suppliers. I'd now like to focus on recharge ponds, please. The public water providers have asked COGCC to include protections for public water supply recharge ponds. Recharge ponds are used by public water suppliers to store water in type 3 aquifers in times of bounty for the use when needed. Every drop counts, since considerable growth has placed additional burdens on already scarce water resources. The latest versions of the proposed rules did not include that change, which leaves the town and other water providers, public water suppliers, recharge ponds vulnerable. Wells and recharge ponds are constructed in the same type 3 aquifer and are equally susceptible to contamination. Wells and recharge ponds are connected through the aquifer. If the soil or aquifer material was contaminated by an oil and gas spill near or at the recharge pond, the town might have to restrict use of the pond until the spill was cleaned and remediated because of the fear of potentially further spreading of the spill and contamination away from this pond. It is important to note that recharge ponds utilize the unsaturated portion and saturated portion of the aquifer to infiltrate recharging water. The infiltrating water from the recharge ponds could intercept a spill or leak that is located within the unsaturated or saturated zone and carry that spill leak to an area of recharge influence. Thus, the recharge ponds can potentially spread the spill. In addition, if a spill occurred near the town's well field and the recharge ponds were operating, the gradient of the water table would be increased near the pond, which would increase the travel time of the contaminant and narrow the capture zone. In other words, we would capture it a lot faster. A spill or leak occurring near a recharge pond could mean that we would need to stop operating our ponds and until the spill could be contained and remediated. This puts the operation of the well field in jeopardy since the Box Elder Wellfield project operates jointly with our recharge ponds. As a result, the town recommends that COGCC extends protections to public water supplies. Thank you for your time, and I'll now stop sharing and turn the time over to Scott Niebuhr.
Thank you, Heather. Good afternoon. I'd like to thank the Commission for the opportunity to speak today. How are we on time?
Ms. Larson? Why don't you go ahead with your presentation since I'm not hearing from Ms. Larson, and I'll check in with her and find out.
Okay, thank you. Again, I'm Scott Niebuhr, the Operations Manager for East Cherry Creek Valley Water and Sanitation. I'm a Colorado Class A certified water treatment operator with 25 years experience in advanced water treatment. I'll be representing East Cherry Creek Valley Water and Sanitation, or ECCV, and Arapahoe County Water and Wastewater Authority as AQUA. Scott Medford has talked about our raw water delivery earlier. I'd like to focus on ECCV and AQUA's water treatment plant and the process. Starting with the system overview. The Northern Water Treatment Plant is located at I-76 and Bridge Street in Northern Adams County and provides water to approximately 100,000 residents. Water pumped from the 17 wells in the BB draw is treated using reverse osmosis. The RO treatment plant is a 4-stage facility with ultraviolet bypass and has a rated capacity of 20 million gallons a day. At the treatment plant, salts are removed from the alluvial well water and concentrated into a brine. This brine is disposed of through 2 injection wells with high pressure pumping systems. These 11,000-foot wells are permitted through the Environmental Protection Agency's Class 1 injection program. ECCV and AQUA have invested $59 million for construction of the treatment facility and $18.2 million for deep well injection facilities. This does not include conveyance facility capital costs.
You've got about a minute and a half left, by the way.
Okay, with that, I would like to move directly to the water treatment system and process. So the first system in our treatment process is a 5-micron filtration system. This system will not reject hydrocarbons, those contaminants that come from oil and gas. Hydrocarbons would then enter the first of 4 stages of aromatic polyamide composite membranes, operating at 95% recovery. Hydrocarbons would be absorbed by those membranes, causing physical change to the membrane layer. This damage would increase pressure or completely damage and increase salt passage in the membranes. By the 4th stage, the membranes would have a hydrocarbon loading of 15 times that of the raw water, increasing the probability of catastrophic failure. The breached membranes would then allow hydrocarbon contaminated water to enter ECCV and AQUA distribution systems. Either of these events would be non-recoverable and require a full replacement of the membranes. ECCV and AQUA are sensitive to potential problems a petroleum release could have on our facilities. Release from a condensate tank at an oil and gas facility several years ago forced us to shut down wells in the area for over a year. Currently, ECCV and AQUA are larger and we have much higher demands. Any long-term shutdown of the system would be catastrophic for us. We would not be able to supply water to the systems. So, and with that, I will conclude, and thank you very much.
Does that conclude the presentation?
Yes, it does. Thank you.
Okay.
We're happy to take questions.
Okay. All right. Thank you for that presentation. I I guess I'm going to ask this question to sort of lead us off, and that is that I thought that I had seen great collaboration and great work amongst all the stakeholders around the public water supply issues. I think it was a very important issue, and I was, from reading all the background materials on it, I wasn't coming into the hearing with the perspective that we had a fairly significant weighty issue that had not been worked out or not sort of figured out. And I heard earlier from industry that they did not want the recharge areas, and now you're saying you should. Help me out. Why are we, what's the discord? What are we missing? And I say that because this is 45 minutes of pretty technical testimony to our body, and help me so that we can move into the deliberation front with better perspective. And commissioners, if I'm the only one who's not getting it, I'll rely on all you guys' experience, but anyway.
I can try to take that on. So we agree that the collaboration was really wonderful. We focused our big asks on the type 3 well protection and are thrilled that that's in the latest rules. In our pre-hearing statement and response statement, recharge facilities, screen sharing again for some reason, but I'm not sure why.
You're not.
Oh, am I not? Okay.
No, you're not.
In our filings, we did mention recharge facilities and ephemeral streams and equal protection for type 3 and Goody wells as more minor issues that were important to us. So I think what I'm trying to say is when the latest rules put in protection for type 3 wells, that was our big ask, and we were so thrilled to get that. And that, like you said, was the result of really great collaboration that we really appreciate. These issues we're following up on now are very important to our clients. They were more minor issues when this rulemaking started for us.
Thank you. Other questions for this panel from commissioners? Ms. McGowan.
Thank you, Mr. Chair. Thanks for your testimony today. I have a couple of questions. Do we know the number of estimated recharge areas? So you showed the total Goodies and the total type 1s. Do we know how many recharge areas there are?
Maybe I could respond to that. I think there's been some misunderstanding maybe of what constitutes a recharge area. And what we're talking about are really discrete structures that have been constructed for purposes of recharge. And Chris Sanchez has worked with some of the people at the state, and with enough filtering of the state's database, it looks like there may only be 21 or so of these facilities currently in operation in the state. There's probably another handful that are decreed through various water courts that have not been constructed yet. But there's not a huge number of them, and they're not broad recharge basins. We're not talking about collecting all of the precipitation that goes into a basin like might be conceived of as a geologic basin. These are very discrete and very identifiable structures that allow water to directly impact the aquifer.
Thank you. Mr. Chair?
Yeah, and sorry, my apologies for interrupting. Just to clarify, that's 21 structures within 1/2 mile of public water supply system wells. So there are other structures throughout the state. Just wanted to provide that clarity.
Commissioner McGowan, a follow-up.
Okay, so that might answer my second question, which was, is there general geographic overlap with the location of a recharge well with a type 1 well or a Goody? Are they generally in the same area, or are they not going to be in the same space generally?
Our primary recharge facilities are close to our production wells. There are other recharge facilities that are part of our system that are further downstream, and they directly allow contamination to get into the aquifer, but they are further away from some of our production wells. Most of our key facilities are located within our production field, though.
That's also correct for town of Castle Rock. Our recharge ponds are located near our public water supply wells and the city of Aurora.
Commissioner McGowan, keep going.
Okay, thank you. So, sorry, I need to clarify two more things. One, which is, I think what you're saying is that you worked with the stakeholders to get type 1 wells added to the draft rules, and they're there and you're excited about that. But now you're asking for them to be treated the same as the Goody. So you want internal, intermediate, and external, why can't I think of the word? Boundary's not the word I want. What's the word I'm looking for?
Buffer.
Buffer. Is that what you're saying? Or are you pleased with the fact that type 3 got added and this is what you came up with? The language that's in the draft rules is the language you agreed to with stakeholders?
So we've been speaking with industry, but haven't reached a consensus on anything yet. The language we've proposed, we thought we might be able to reach a consensus on, which is why we proposed putting recharge facilities into 411C, where type 3 wells currently are. And in reality, we think recharge facilities deserve the same protection as Goody and type 3. But we recognize that this is a big ask late in the rulemaking, and we thought it'd be easier to reach consensus with less protections for recharge facilities.
Okay, so sorry, maybe I'm not asking my question right, or maybe I'm misunderstanding our own draft rules. The way that I read the draft rules is a type 3 has no construction within 0 to 1,000 feet. The Goody has like a 3-tiered different things that have to happen within 3 different types of buffer zones. So they are treated a little differently. So when you say you want a recharge area to be treated the same as a type 1 or a Goody, I'm not understanding what it is exactly. Sorry, I know it's a fine point, and maybe I'm misunderstanding our own draft rules.
So I think you've got the gist of it. Right now, Goody has the most protections. It's in 411B. Type 3 wells have lesser protections. They're in the next section in 411C. And recharge facilities are not in the current rules.
Correct. And you're okay with type 3 staying as it is, but you'd like to add recharge facility.
Actually, we would like type 3 to be treated the same as Goody. Mr. Sanchez in his testimony described why type 3 wells are often just as vulnerable, if not more so, as Goody. And we don't believe that the definition of Goody has much to do with the need for extra protections. I think type 3 is just as vulnerable. So,
yep, I got that part. Sorry, you've answered my question. Thank you. Thanks.
Thank you, Commissioner McGowan. Other questions from commissioners to this panel? Commissioner Nanjapa.
Thank you, Mr. Chair, and thank you all. Appreciate the information and the details. One quick note, which I'm not sure if Chairman Robbins already had mentioned, but at least I had difficulty reading some of the slides that you put up and some of the red lines, and so it'd be great if you could send that so that we could take a closer look. And I think the question that Commissioner McGowan just asked helped clarify something, but I'm still a little bit fuzzy at it, and I just wanted to make sure. So when we were talking about the number of these recharge facilities, so number one, we're talking about not like natural recharge basins, but we're talking about specific constructed engineered facilities. Is that correct?
That's exactly correct. And that's the distinction that we're sometimes having a hard time getting through, but that's exactly correct.
Okay. And so would it, and then you also noted that there's about 21 of them, but then you also added a clarification that these 21, there's more than those, but there's 21 that are within a half mile of a production well within a public water supply system. Is that correct?
that's correct.
Okay. And so then I'm just kind of thinking about this, you know, how we could include this. Would, within our definition of the public water system, would you say that these engineered facilities are part of the system that provides public water for human consumption in terms of their proximity, specifically these engineered facilities that are close to production wells? My understand, would that be a way of capturing them in potentially in our definition, or is it your preference to have them either defined separately or otherwise included as part of the Goody category? Does that make sense, what I'm asking?
I'm not sure I totally understood you. Our preference, we've given a lot of thought to how many of these recharge facilities fall within, for example, the internal buffer zone around type 3 wells. Would they be included anyways? We've given that a lot of thought, and our preference is to have a separate category for recharge facilities.
Commissioner Nanjapa, did you have follow-up?
I think that helps. I think I'm closer than I was before. Thank you.
And Ms. Brownhill, my notes are probably bad, but when industry spoke to this issue, I have down not possible to consider the request because the locations cannot be determined. But I think I'm hearing from your witnesses today that there's 21 discrete locations plus a handful that have been decreed and they aren't built. Who's right?
Let me elaborate on that. And we've been having really good conversations with the Division of Water Resources, and even the last couple of days. So the information when industry was presenting may have changed. The Division of Water, and I'll let Chris Sanchez chime in too in a second because he's the one who's been getting most of the data. But the short version is there are 21 recharge facilities within half a mile of public water system wells. Those are the ones we think are most vulnerable, but it doesn't include all of them. United has several recharge facilities that are outside of that half mile. So when we say 21, we say that to give you an idea. It's a very small number, but that's not a number that we've evaluated as much as we'd like. And Chris can go into more detail. That the problem is the Division of Water Resources hasn't found an easy way to identify the public water system recharge facilities amongst other recharge facilities. So we're still working on how to identify a correct number. Chris, do you want to add to that?
You bet. So the data set that we are relying on comes from the Division of Water Resources database. And part of that database includes structures that are used for recharge or recharge areas. The number of just recharge facilities statewide over oil and gas basins is a much larger number, on the order of 900 or so. But it's important to understand that that larger number includes anything ranging from ditches that may function as recharge for water rights purposes, or water rights augmentation plans that deliver water back to the stream, or other more agricultural type recharge facilities. So what we have been working on, and some of this is hot off the presses literally as of this morning, is just trying to identify how many of these structures exist in close vicinity to PWS structures overlying oil and gas basins. And with the help of the DWR, we have been able to narrow that number down to 21 in the vicinity of the actual PWS structures. So I think there's some data evaluation that can be done, but we have made good progress, at least identifying the locations of structures statewide, and that information has been provided with industry. But a lot of this information has been coming together just in a very recent time frame, again, literally as recent as this morning here. But we are encouraged that data are available to sort this thing out, but part of what the data set lacks is the clarification of whose structures those are and whether or not they're associated with municipal PWS facilities or what have you. So there is still some more work to be done, but I think what we're seeing based on the data review is that there's a lot of promise and opportunity here to narrow those down based on the structures that are identified in close vicinity to public water system facilities.
Thank you, Mr. Sanchez. Do we have other questions from commissioners? Commissioner Messner.
Thank you, Mr. Chair. And thank you for that presentation. I mean, it was a little bit hard to read, but I also think that the testimony and the information to me was really important. I do think that the protection of public water systems is of incredible importance. And certainly the number of public water supply operators that are presenting this information is compelling to me. It does make me, I mean, I'm going to agree with Chairman Robbins is that why haven't we sorted this out in some of the stakeholder work prior to this? You know, Ms. Brownhill, you're indicating that these are minor issues. That presentation didn't seem like they were minor issues to me. And so I'm wondering, you know, certainly I think that if there is the potential contamination of drinking water and we need to, you know, evaluate setbacks, and you as professionals are vouching that this is important stuff, to me, that's things that we need to be thinking hard about. And I am wondering why these were considered minor issues going into the stakeholder process. I mean, maybe initially you could comment on that, and then I'd like to get into the details of what your ask is, if I could, after that.
Sure. I completely agree that these are important issues. I may have misspoken when I called them minor, and let me explain that. When we started this rulemaking and we're working with staff, some of the feedback we got was that type 3 wells were not going to be considered. And so we mentioned recharge and we mentioned ephemeral streams in our pleadings, but chose to put most of our weight and effort into getting type 3 wells into the rules. And that happened, and it was a really good collaboration in the end. And we're happy to see those there. But these other issues, as you said, Commissioner Messner, are still very close to our heart, and we would like to see them added to the rules as well.
Commissioner Messner, can I just follow up quickly? So are you guys still having talks with industry about this?
Yes, we are. We spoke with Great Western on Monday.
Anybody that says we should lock them all in the room and get them to figure it out, raise your hand by saying aye. I mean, you know, I agree. I appreciate the testimony, appreciate this. I think we all want to protect public water, but it seems like you have a legitimate point that this should be protected. It seems like some of the concerns industry raised ought to be work-outable. We're not going to vote on 400 series today, so y'all go figure it out and come back tomorrow morning with something that works. And I'm not trying to be flip at all. Very important here. Commissioner Messner, did you want to follow up now that I've let my tirade out?
I will, and you know, because I just want to reiterate what I think the ask is, and please explain it to me differently if I'm wrong. But what I'm hearing is recharge facilities, engineered recharge facilities, and I think that was, to me, an important definition, or an important clarification to the definition, was an engineered recharge facilities. Type 3 wells, Goody wells, all equal protections, and then we need to revise the definition of a classified water supply. And those are the asks, right?
That is correct, yes.
Okay. And to me, that makes sense. It seems like we should be able to get somewhere on this. And so, yeah, thanks.
My fellow commissioners, I nominate Commissioner Messner to get into the room with these groups and figure this out. He can be the referee. Commissioner Gonzalez, do you have a pertinent question?
I don't know how pertinent it is after you've just given them all homework to come back with a better answer, but I will ask based on the information I got today. So I'm trying to understand kind of these recharge facilities, and it sounds like one of the concerns from industry that we heard about this morning was was the identifiability of them. And it sounds like from what I hear today, or from what I hear in the last few minutes, is that these locations are easily identifiable with certainty, but who owns and operates them is the next level that that maybe not as readily accessible. Do I have that part right?
Yes.
Okay, so certainty, identifiability, easy. You know where they are. So a buffer is easy to determine. Okay, that helps me frame this a little bit. My next question goes to the ephemeral streams question and the variance in definitions. So in the statement of basis and purpose, the staff identifies two different, or I guess a distinction in definitions from the WQCC for intermittent streams and ephemeral streams. And I'm curious if I can get some more clarity on that, either from the group, the panel that's here, or from staff.
I believe that I'd first like to hear from staff. I'd like maybe AAG Minor.
Thank you, Mr. Chair. I think the first thing I'd like to do is correct the record. Ms. Justice said on several occasions that staff proposed removing ephemeral streams from the definition of classified water segments. That's not correct. Staff did not actually change the portion of the classified water supply segment definition that was highlighted on the screen. That has been in the Commission's rules, the language about perennial or intermittent streams since 2008. The only change that staff proposed to the classified water supply segment definition was to update the incorporation by reference to ensure that the most recent version of the Water Quality Control Commission Regulation 31 was incorporated. So that was not a substantive change. The rule. Staff was intending to continue to implement that as it has been implemented since 2008. In terms of the statement of basis and purpose language, to more directly answer Commissioner Gonzalez's question, the intent of that language was to simply clarify that there are different definitions of intermittent stream, perennial stream, and ephemeral stream under the Water Quality Control Commission's rules. I'm not sure that I am qualified to speak to exactly how the Water Quality Control Division implements that in terms of their classification stream, but that distinction among the definitions in Regulation 31 was all that staff intended to do, is highlight that those are defined differently. However, the actual practice of how the Water Quality Control Commission implements that was not what staff was intending to get into by noting the difference in definitions in the statement of basis and purpose.
Terrific.
Director Murphy.
Thanks. The one other piece I would add is that when we were discussing this question yesterday about coordinating with water quality, I think it came up in the context of a question to Commissioner Putnam. I said that we had been in communication with water quality on it, and we have, and we will continue to work with them on it as we finalize these rules.
So is there any, yeah, so what I'm getting at is we're kind of piggybacking on the WQCC definition by incorporation. Is there a need in order to fulfill our mission to expand that on our own within our rules beyond just the incorporation by reference? And I hope I'm on the right line here.
Can I ask a clarification, Commissioner?
Yes.
Is your question, thank you, Chair. Commissioner Gonzalez, is your question, should we include ephemeral or not, to put a really fine point on it?
Should we take it should we take it on ourselves as the COGCC to include ephemeral within our surface water definition?
Director Murphy or Attorney General Minor?
Thank you. I know the parties have briefed this clearly. The parties before you say yes. I think some of the industry groups said, please don't. I think I need to check back with our staff as to our technical perspective on it. And I can do that shortly.
Thank you. And I think my next question is with regard to ephemeral streams versus intermittent or perennial streams, is there the same level of certainty for identification that exists for those different types of water? And that's that may not be for staff, that may be for the panel as well, but I'll let staff chime in, Director, if you are ready for it.
Give me 2 minutes maybe to make sure I'm correct.
Okay.
Does any member of the panel desire to answer the question from Commissioner Gonzalez?
I can try to answer that question.
Ms. Justice.
We have had several conversations with CDPHE, mainly because in my mind, I had never seen CDPHE classify a stream as perennial, intermittent, or ephemeral. And so I was pretty confused when I read this classified water supply segment, because I know based on the EPA's Safe Water Drinking Act that no waters are left out when identifying water supply. So when talking to CDPHE staff, we asked them, do you classify the stream segments by perennial, intermittent, and ephemeral? And based on those conversations, they said no, they don't. That if it's classified as a water supply, it doesn't matter if it's perennial, intermittent, or ephemeral. They can look into it, and it can be one of the parts of their review, but it doesn't matter. And I think what I was trying to say in my testimony is that if the CDPHE has classified it as a potential water supply or water supply, it should not be excluded based on whether it's perennial, intermittent, or ephemeral. It does not matter. The only thing that matters is the classification that CDPHE has classified it as.
As just a classified water segment.
As a classified water source, and then there should be no reference to intermittent, perennial, or ephemeral. And the CDPHE does know which segments they have classified as water supply.
And so any classified water segment, regardless of whether it's one of those three categories as we talk about them here, they're all, again, and I'm going to keep on talking about this, identifiable with certainty, right? Because we're writing rules here, and so you've got to be able to tie them to something.
Yes, the CDPHE has to go through and classify stream segments, and they have mapping available.
If I might, Commissioner Gonzalez, CDPHE is already buying these. Oh, sorry. Thank you.
Just want to get the record of who's talking.
Great, appreciate that. CDPHE has already classified those as potential public water supply or existing public water supplies. Those are already on the Colorado Gas Conservation Commission map. And really what we're doing is just fixing what is probably, was not accurate in the first instance, because there probably are currently segments that are being protected pursuant to COGC rules that are, both perennial, intermittent, and perennial and intermittent, and the other classification. Sorry.
Ephemeral.
Ephemeral. Thank you. Thanks for that.
Commissioner Gonzalez, any follow-up?
Thank you, Chair. Nope.
Commissioners, any other questions for the panel? Okay, seeing none, I will Zoom you away to go talk with industry and come back tomorrow with hopefully some nice solutions, and you can talk with our staff as well. Thank you for the panel discussion. It was very good information. It's an important topic. And so with that, I believe, Ms. Larson, help me, but I believe that is the end of party testimony on the 400 series. And our next move is to closing statements and then staff closing. I might suggest a short break before we move to closing statements, and then Ms. Larson can get the closing statements together, figure out who's doing it, and then it'll give staff another little bit of time to get ready for their closing statement. So it's 2:20. Let's adjourn briefly until, well, we're not adjourning. Let's turn off our screens until 2:30, and then we'll come back at 2:30 and we'll move into closings. Welcome back, folks. It's 2:30. our 10-minute break is now up. And we have closing statements. Would turn to Ms. Larson for identification of those parties who will be participating in a closing statement, as well as time allocations.
Yes, thank you, Mr. Chair. So 3 parties have elected to make a closing statement. The first is industry, and you may recall we had industry group 1 and 2 separate presentations. They've elected to combine and present together for purposes of closing. And they have 18 minutes and 17 seconds left as a combined amount of time to present a closing statement. Battlement Concerned Citizens also will be presenting a closing statement. They've asked to spend 1 minute on that closing statement. And La Plata County will also be presenting for 1 minute a closing statement.
And then we would move to staff, who has unlimited time, but I'm sure will be efficient. With that, why don't we bring the industry closers into the house? Good afternoon, Mr. Neslin.
Good afternoon.
I see Justin Caskey and Kelsey Wazelinski.
We're all on.
And you have Jason Oates. Is that the closing panel?
Yes, Chairman. Are you ready for us to begin?
I believe we're ready.
All right. Commissioners, good afternoon. I'm Dave Neslin, speaking on behalf of the industry groups. Let me set your mind at ease. We're not going to use 18 minutes here. We'll try to be efficient. And I want to emphasize up front, again, that we generally support the 400 series rules. We've offered just a few suggestions on a couple of rules, and we continue to commend the staff and the stakeholders for the thoughtful approach that the rules reflect. I'm going to introduce Justin Caskey. Mr. Caskey will speak. I'll speak a little more. Then Mr. Oates will speak, and then Ms. Wazelinski will speak, and that will conclude our closing. Mr. Caskey?
Thank you, Mr. Neslin. For some reason, I can't get my video going, but my statement's fairly brief, so I will go with that. So thank you. My name is Justin Caskey. Thank you for the opportunity to return and offer additional comments on noise. Specifically, I have brief comments on the testimony of Dr. Blair earlier today. My first comment is that Dr. Blair stated that they used short-term attended measurements to validate the longer-term continuous dosimeter measurements. I wanted to highlight that the attended measurements were extremely limited. They accounted for 82 data points out of a total of 350,000 non-attended measurements. The non-attended monitoring had no way of separating oil and gas sound from other community sound. The addition of the two data sets, the two data sets use different monitoring equipment and different methodologies, making it difficult to compare or validate the two data sets. My second comment is that the wind speed cutoff point of 10 miles per hour used in the noise study likely skewed the sound survey results upward. We know that wind produces C-scale sound. Even at wind speeds well below 10 miles per hour, contamination from wind skews monitoring results. The COGCC currently uses 5 miles per hour as a cutoff for testing, and other jurisdictions have similar cutoffs to avoid this problem. In my experience, the cutoff for wind speed for C-scale sound set at should be lower than 10 miles per hour to avoid skewing the results. Given these points, I believe that the noise study presented by Dr. Blair included limitations that likely skewed the results of the noise study higher than what would be representative of the well pad studied. In my opinion, the study should not be used as a basis to set regulatory limits. Thank you.
Commissioners, this is Dave Neslin. I want to briefly respond here to several of the local government requests for different standards and procedures regarding noise and light. And we would urge you to remember that Senate Bill 181 grants local governments express authority to regulate surface impacts of oil and gas operations to address noise and light. The Act also authorizes local governments to inspect facilities and to assess fees for enforcement purposes. So if a local government wants more stringent noise or light standards for their jurisdiction, they can and should adopt them as contemplated by Senate Bill 181. But that should be a local decision, informed by local experience and objectives, and not a statewide rule. And that's particularly true in this situation. The staff's proposed standards reflect substantial effort and have received broad support. Noise and light are not technical oil and gas issues that require COGCC expertise. They're issues that local governments are familiar with and deal with regularly. And there's no general agreement on an alternative standard. Indeed, some local governments have advocated standards that differ from what they impose on other land uses. These differences are described by an Occidental witness, Kim Mendoza-Cook, at pages 16 and 17 of her written testimony. For example, several of the affiliated local governments urge a noise standard of less than 60 decibels during drilling and completion. But they apply a noise level of 80 decibels for road and building construction, which are analogous to but more widespread than drilling and completion. Now, there's nothing wrong with that, but it illustrates the diversity of approaches to these issues. I also want to highlight two provisions in Rule 423 noise that provide the director with flexibility to ensure that public welfare is protected in each case. Rule 423B3A provides that the director can require operators to comply with lower noise standards if a location is within an area zoned industrial or commercial, but is within 2,000 feet of a building unit. And that rule addresses the scenario that was discussed yesterday and displayed in a slide where an industrial or commercial area is adjacent to a residential area. That kind of situation is already addressed by Rule 423B3A. And Rule 423E authorizes the director to require operators to take additional action if operators cause persistent noise that adversely affects public welfare. And that will allow the director to address problematic situations on a site-specific basis, which we agree is appropriate and which we support. Finally, I want to support Mr. Minor's response earlier today regarding the importance of consultation with CPW, BLM, and the U.S. Fish and Wildlife Service through the planning process. Those agencies have expertise on noise and light issues, and they can help in addressing unique site-specific needs and protecting wildlife, particularly during the temporary drilling and completion period. That concludes my statements, and I'll now turn the microphone over to my friend Jason Oates.
Thank you, Dave. Thanks, Chair. First, I'd like to thank the COGC staff for their hard work, not only over the last several months during the rulemaking process, but also over the previous months and years working with operators and the public to find common ground. A special thank you to Mike Leonard and his staff for their professional approach when following up and working with operators during operations. Second, Crestone supports the August draft of Rule 423 as written. In my testimony, I covered the 4 key points to consider when evaluating environmental noise studies: the relationship between distance and noise, sensitivity of low frequency noise to wind speed as previously covered by Mr. Caskey, the importance of an accurate and representative sample of the ambient environment, and a systematic approach for addressing external noise sources. You heard testimony on the impacts from near noise from oil and gas development. This testimony did ignore or fail to disclose how they address these key points in their testimony. These key points should be disclosed or clarified before factoring these studies into your deliberations. Finally, in closing, Crestone supports Rule 423, and we look forward to working with the COGCC staff on the necessary guidance needed to implement these new rules. I'll now turn the presentation over to Ms. Wazelinski for her closing remarks. Thank you.
Thank you, Jason. My name's Kelsey Wazelinski. I'm with Jost Energy Law, and on behalf of myself and Jamie Jost and all of our clients, we would first like to thank you, staff, and all stakeholders for their engagement on the 400 series. I'll briefly respond to several of the positions set forth by parties on Rule 411. I'd like to acknowledge and reiterate the point made by Assistant AG Minor that numerous rules are intended to protect groundwater and public water supplies, and we support staff's position that Rule 411 remain focused on public water intakes. I would also like to clarify that the industry groups do not oppose staff's proposed buffer zone setbacks, including the 1,000-foot internal buffer zone setback. So first, with respect to the classified water supply segment definition, the Public Water Supply Group requested to remove perennial or intermittent streams from the definition of classified water supply segment so that the rule means surface waters classified as being suitable or intended to become suitable for potable water supplies by the WQCC pursuant to Reg 31. And as addressed by Ms. Blanchard in her testimony with the Small Operator Society, Great Western supports staff's definition of a classified water supply segment and staff's intent to continue to apply Rule 411 only to perennial and intermittent streams, not ephemeral streams and drainages, which staff acknowledges are defined differently under the Water Quality Control Commission Reg 31. So Reg 31 defines ephemeral stream as a stream channel or reach of a stream channel that carries flow during and for a short duration as the result of precipitation events or snowmelt. The channel bottom is always above the groundwater table. The Reg 31 statement of basis and purpose states that if the groundwater and flow are not connected, then the system is ephemeral. I want to be clear that Great Western is not opposed to ensuring the protection of any stream segment that could impact surface water. Great Western does, however, want to ensure that the streams subject to Rule 411 are properly mapped and defined so that there is no contradiction with the Water Quality Control Commission definitions and classifications, and so that Rule 411 remains focused on surface water impacts. This really goes to the issue of regulatory certainty. I would also like to note that ephemeral streams are protected from potential impacts as waters of the state. The difference is whether they should be given the same protection for water quality standards as a water supply because they do not have water in them except for short periods after precipitation events. An alternative approach would be to include potential ephemeral stream impacts as a required consultation with the public water supplier to ensure that potential public water intakes are properly protected. Second, on the public water supplier's request to apply the same standards, which are the 3 buffer zones for Goody and type 3 wells, I would also like to reiterate Mr. Duranello's statement in his presentation that where a public water supply is served by a type 3 well that is not a Goody well, the immediacy of risk to a public water supply intake is lower. The protections outlined in staff's draft are appropriate to address the longer migration pathway for type 3 wells. These protections include a 1,000-foot no surface occupancy around the wells and prohibition of chemicals out to 1,500 feet. In addition, staff's draft includes consultation with the public water supplier for type 3 wells within half a mile of the proposed location, which includes a discussion of groundwater monitoring. For these reasons, Great Western supports staff's proposed protections for type 3 wells, however, ultimately does want to ensure that type 3 wells are properly protected. And finally, with respect to the Public Water Supplier Group's request to add recharge facilities to Rule 411, we currently do not have precise data points as to where the specific recharge areas are located that are connected to public water systems. Great Western is frankly only just beginning to review the DWR database with respect to the locations of recharge areas across the state and whether these recharge areas are inside or outside of the proposed Rule 411 buffer zones. Recharge areas can be associated not only with a public water supply, but for private and agricultural or irrigation uses as well. We think there are approximately 1,000 of these recharge areas across the state. Today, the Public Water System Supply Group has represented these to be discrete structures, and there may be 21 in operation in the state within half mile of a public water supply. This is the first time we've heard of this number, and frankly, we've just not had the time to evaluate where these are in relation to surface water supply areas, Goody wells, and type 3 wells. As the Public Water Supplier Group acknowledged today, DWR has not yet identified how to distinguish the recharge areas connected to a public water supply. I'd also like to note that if recharge ponds are located near the public water supply wells, there will be consultation under the proposed rules, which could be a more efficient process to protect these areas. So at this stage in the rulemaking, we do believe we have a strong rule that protects all aspects of public water systems across Colorado. We urge the Commission to refrain from making a quick determination on the public water supplier's request to add recharge areas to the rule until we have been afforded the time and opportunity to review and work through this request. Of course, we're open to discussing this issue further with the Public Water Supplier Group, COGCC staff, and other relevant agencies. But frankly, a consensus by tomorrow may be challenging due to the vast amount of technical data that we need to sort through between now and then. I will commit, though, that we will continue to work through this issue over the weekend, and we do want to just provide a strong caveat that some of the issues presented by this request may take time and further engagement, and we just don't want to rush this important issue for rule language. So in closing, on behalf of Great Western and the other industry parties, we're hopeful that our continued work and engagement on this recharge area issue will result in a consensus. And that concludes industry's closing remarks. Thank you again for your attention and engagement on the 400 series.
Mr. Neslin, does that conclude your closing?
Yes, Chairman, that concludes the industry's closing collectively. Thank you.
Thank you very much for that closing. Noting that it's a 3-day weekend, Ms. Wazelinski, you have an additional day in which to work this out. We'll look forward to seeing you Tuesday morning, September 8th. No, again, all joking aside, I appreciate all stakeholders recognizing that the public water supply issue is important for the state, and I appreciate your continued efforts to work with the Public Water Supply Group. I think they are rolling up their sleeves too. And so, you know, and you can engage staff as well. But we appreciate that Colorado way approach toward addressing issues. So thank you, industry, for your closing. We now would turn to Battlement Mesa Concerned Citizens for 1 minute, I believe. Mr. Sura, we can see your screen and we can see you. I think you have 1 minute reserved for closing.
All right, thank you. The public expects the Colorado Oil and Gas Conservation Commission to make decisions based on a best available science. In this case, 70 decibels C has no basis in science, only in what the industry believes it can achieve. If you don't want to use the studies we've submitted, we encourage you to use the studies in the statement of basis and purpose that your staff has put there that states that the target should be 60 decibels C with a maximum of 65 decibels C. Similarly, there's no scientific justification for raising noise limits for oil and gas development 10 decibels during drilling and completion. The levels proposed in your rules are known to cause health impacts over time. The noise levels proposed during drilling and completion can last for more than a year in a multi-well pad and will harm public health and welfare. Allied local governments join us in this request. I want to remind you that another study that you are relying on states that noise decreases by 6 decibels A every time the distance is doubled. For example, noise 2,000 feet from a home will have a decibel decrease of 12 decibels compared to noise 500 feet from a home. Increasing setbacks will help the industry meet noise limits that protect public health. Finally, we strongly disagree with the proposal by Garfield County to defer to local governments to set their own noise levels on individual permits. The Colorado Oil and Gas Conservation Commission must be a check to ensure public health is protected. Garfield County's proposed language would presume that local government's waiving of noise limits is protective of public health. COGC staff should not have to justify requiring noise limits that are required for the rest of the state. As you have stated, when it comes to protecting public health, safety, and welfare, the buck stops with the Colorado Oil and Gas Conservation Commission. Thank you.
Thank you, Mr. Sura, for your closing statement on behalf of Battlement Concerned Citizens. We appreciate that.
Thank you.
So we will now turn to the La Plata County Coalition for, I think, another minute of closing.
Thank you, Mr. Chair. On behalf of San Miguel and La Plata counties, we just wanted to clarify our ask with respect to Rule 405. We ask for two things. One, that most notices to local government in that rule be at least 5 business days. And the second thing we ask is that local governments receive concurrent notice when notice is given to the commission. Progress has been made with respect to this rule and this issue, such as changing hours to business days. However, some of the staff changes changed 72 hours to 2 business days. We believe this issue is very important to our local governments, that we get 5 business day notice. And they're not just downhole issues for some of the activities, because trucks come in to perform the downhole activity and various surface impacts occur. So we would greatly appreciate the increase in notice. Thank you very much.
Thank you. With that, I think we are done with closing statements from parties. And normally we don't take questions during closing statements, but if commissioners desire, it's our rulemaking, so we can do we can do questions. I just sort of throw that out there for you guys, and we can also Zoom people right back in case we miss something. Commissioner Gonzalez, did you have a question?
Thank you, Mr. Chair. I appreciate that. You know, one of the interesting things, the way that this was set up for this series and for other series, we heard from industry first, kind of heard all their arguments, then we heard a bunch of, varied arguments and testimony from both local governments and concerned citizens groups. And I want to make sure that everyone has had an opportunity to respond to all that. And there was one important question that Commissioner Messner brought up sometime, I think maybe yesterday afternoon, about the table 411. The table in 411 about the chemicals and the prohibited chemicals within the intermediate boundary for Goody wells. And his question was, why don't we just expand that statewide? And I think that why question is a big one, and maybe something for us to consider. But I think most importantly is I'd like to hear from industry is if they, what objections they would have to that table of chemical prohibitions being applied in a general nature. It's a question I don't know the answer to, and I'd love to hear from any industry rep who'd be willing to take a crack at that.
You want to? I'm not sure. Okay, here we have Mr. Neslin showing back up.
And
Ms. Larson?
I would also say if there is an industry representative who is...
Can they raise their hand?
Exactly. They can raise their hand and we can bring them in.
Commissioners.
When there are a couple of mics in your room, so if you could get all but one turned off.
Did you get it? All right. Okay. Commissioners, I'm sorry, I was distracted. I think you had raised a question, Commissioner Gonzalez, I think raised a question about industry's position on extending the table 411 list of chemicals statewide beyond 411.
That's correct. We heard some testimony about requests to move that beyond just the intermediate zones around Giddies, and if they are not as commonly used or are being phased out or whatever. Just wanted to get industry's feedback on the effects of expanding that statewide.
And Commissioner, I'm going to apologize. I think I'd need to confer with the other industry parties before I could answer that on behalf of the industry. So if we could get back to you, and I will do that now and try to get back to you this afternoon.
Mr.
Commissioner Messer's got a question. I'll defer to him first.
maybe what you can do is you can have a minute in the morning to get back to us on that topic. That'll give you the afternoon to think about or find the appropriate industry rep. I'm actually going to suggest that after we take closing from staff, that we actually adjourn for the rest of the afternoon, and there's some reasons for that. So we're not going to likely be here for the rest of the day. So Commissioner Gonzalez, are you comfortable with that, or other commissioners?
Yeah, I'm very comfortable with that. I think Commissioner Messner raised his hand. I'm going to punt to him in just a second. You know, there's one other question I want to ask, and the reason is because I want to make sure that in our deliberations we really understand the effect of some of the things that we're considering. So I want to make sure that that we have that position. So the next question I have for industry is, what are the effects of expanding the Goody standards to all Type 3 wells? So I don't need an answer today, but something to think about and get back to us as we prepare for deliberations. Make sure that we get to the best right answer.
Certainly.
Commissioner Messner.
Thank you, Mr. Chair. And I do just want to clarify the statement that I made, is that it was my understanding from industry that this was a list of chemicals that, in discussions that I've had, you know, previously, that are not often used anymore. They're fairly nasty topics. There are fairly nasty chemicals, and they're being phased out. And so my question was, if they're being phased out and best management practices in the near future may indicate that these should no longer be utilized in operations, then what would the impacts be of expanding the application of the banned chemical list into other areas? We heard some testimony around, at a minimum, expanding it to the external buffer zone. My question was, is there other applications where we would want to expand the banning of this, understanding that local jurisdictions in parts of the state are already doing this without any significant concern from industry? And so I would just be curious to know if that is the case, and if so, should we consider a further ban for these chemicals in different applications? So
Thank you for that clarification, Mr. Messner. Mr. Neslin, I think you've got your marching orders. We'll look forward to hearing back from you for a minute or two tomorrow morning. Commissioner Najaba.
Thank you, commissioners.
Actually, before we dismiss you, Mr. Neslin, I had a question as well. Thank you, Mr. Chair. Sorry, you had mentioned in your closing comments about the local government authority and in particular with some of the noise and light and related standards. Do all local governments have established standards already that you are working with? And what do we do when they don't?
Commissioner, first of all, the statute grants this authority to all local governments. So this is authority available to all. In my experience, local governments where oil and gas is occurring do have standards of this sort that they apply to multiple industries. Noise standards, lighting standards, and typically it would maybe part of the building code or the land use code, or they may have a nuisance code that memorializes these. I believe that all of the affiliated local government group have such standards. In my experience, Weld County has such standards, Garfield County has such standards, et cetera. So I think all of the local government parties to this rulemaking have such standards. If a local government did not have such standards, then certainly the commission's standards and rule would apply. Commission rules would apply. I believe they're good rules. I think that the standards set forth in the rules reflect a great deal of work by the staff and consensus by parties. And as I noted, there are specific rules that allow the director to go beyond those standards in appropriate cases to protect public welfare. So I think it's a good mix. The proposed rules reflect a good mix of thoughtful standards, but also performance standards and discretion on the part of the director to ensure that public welfare is protected in each case. Does that answer your question, Commissioner?
Yes, thank you.
Thank you, Mr. Neslin, and thank you, commissioners. I think Commissioner Gonzalez just established a brand new and better way to conduct closing, which is we should ask questions if we have them, because it just helps edify the discussion. So thank you, Commissioner Gonzalez, for being nimble and astute. And we will, from here on out, make sure we have commissioners with an opportunity to ask questions. Mr. Neslin, you are excused. I would like to bring in Ms. Murphy for the staff closing. And before we go to that, or maybe Ms. Murphy, we can have the discussion about the rest of the day before you do your closing. I know that we are ahead of time, ahead of schedule by some 6 hours, although Ms. Larson totally messed it up by giving us a new schedule that makes it look like we're on schedule. But we really are ahead of time by about 6 hours. And in discussions that I had with Director Murphy offline, that has sort of pinched staff a bit because they had planned this out in terms of getting ready for 600 and 600 presentation, and all of a sudden they're jammed. And so I think that the direction that we should give to staff is let's hear from staff in closing, and then let's halt for the day and give staff the chance to get caught back up. Director Murphy, I'll pause there and let you weigh in on any of that.
I will be brief and succinct. Yes, please.
Okay.
I think it would help us be a little bit more organized. If the commissioners want to send me kind of their list of topics in the evening, we can make those available to parties, and I can like preload a presentation for to get us started tomorrow morning a little bit more quickly in acknowledgement of that gift of time.
So what I think I heard you say, Director Murphy, is the next step for us normally would be for us to parse through our notes, find the significant issues that we think exist with 400 so that we can create the Google Word doc that we then work off of as we go through the issues. And what we can do is get those ideas, issues, et cetera, to you, this evening, and that you could go ahead and develop that doc, make it a shareable doc, or Ms. Larson can make it a shareable doc so that the rest of our stakeholders can see that document. And then in the morning, we can, start right into deliberations without having to spend, an hour or so developing the issue doc. Is that right?
Yes.
Okay. So what we'll do, we'll do that. And then in the morning, what we'll start with is sort of a make sure that we got it right issue doc discussion so that folks can see that we have gotten the issues identified. Okay, with that, Director Murphy, if you could give us your closing, or yes, you and staff give us your closing.
You're correct. It will not just be me. This is entirely too technical. I'm going to queue up a presentation first. It's incredibly brief. Hopefully, folks can see that. Oh. Oops, sorry. There's all the slides, all 4 of them. And I don't have it in full slideshow mode. And now you can't really see it. Forgive me, I'm trying to navigate notes and all sorts of different pieces. Okay, so where I would like to start is to acknowledge the consensus, which is very typical of me, and you'll probably be tired of me saying that by the end of this, but there has been an incredible amount of work and I'm grateful for it. I think that Mr. Nguyen summarized it nicely in that there are 3 or 4 or maybe 5 like key issues that are continuing to engender a lot of important discussion and dialogue. The other piece I wanted to hit in my closing is that, again, 300 and 400 are very closely related. We spent a lot of last week talking about the 300 series and how we look at permits and what information we expect to come in those permits. And we looked at the 400 series to provide a number of the substantive pieces. And I think that that's true for other rule series, but since we're on 3 and 4 right now, I'll focus on those 2. I think many of the questions that the commissioners asked that parties brought forward focus really on this interrelationship between 3 and 400 series. So staff in our closing remarks are going to backtrack a little bit to move us forward and to just frame the complementary provisions between the 300 and the 400 series. So both AAG Minor and Mr. Andrews will talk about this interrelationship. Mr. Andrews will first begin by discussing the timing of phases and operations and flag associated notices. And this goes to the conversation we had today about how long does it take to do these different things and when do we get notices out. Then he'll hand it off to AAG Minor, who will expound upon the topic and discuss some of the subsequent operation pieces and may jump into kind of the clarification of the water segment definition. I know we covered it, so he may not actually address it. A couple of other pieces, AAG Minor will hand it off to Mr. Leonard to talk about the nuisance regulations. You know, and we, in 420, in the Lake 400 series, you know, and we crafted those regulations with a lot of input, a lot of expertise, a lot of experience, and all of those different pieces from a broad group of interests. The work product resulting has received concerns kind of from a number of different perspectives, but I think Mr. Leonard is going to cover at a high level why we think the standards staff has proposed are appropriate given the wealth of information that staff and the parties have considered and brought forward. You know, as it relates to the local government engagement in this space, we'll look forward to your direction on that piece. Talking now to kind of the issue of the moment, Rule 411. Its provisions have received very careful attention from us, from Water Quality Control Division, from the Division of Water Resources, of public water suppliers and operators, to name just a few. But it seems we have a little bit more work to do. We won't spend any time today reiterating what staff's proposal is, but I think we would ask for the latitude that Chairman Robbins articulated earlier to work with these folks over the next few days to try to bring forward further refinements, and I remain optimistic we can work towards additional consensus. Last, during commissioner discussions tomorrow, we would ask that you support staff's proposed revisions to 429 and 430 that Deputy Director Cuthbertson discussed today. So with that, that completes my suite of introductory remarks, and I would turn it over to Mr. Andrews to talk about the phases and timing and notice.
Thank you, Director Murphy. Can you guys hear me okay?
Yes.
And Ms. Larson, it is not letting me share, or will you be running the slides from over there?
Mr. Andrews, I've actually got the slides. I'm a multitasking director today.
Okay. Thank you. Let me get back to the right view. For some reason, I am not seeing your screen, but I have another copy of the slide in front of me. So, well, we'll start with DJ Basin. The objective I was given here was to get with staff and summarize the essentially durations of different operations. And we focused mostly on normal operations for drilling a well. So there are certainly other notices out there in our rules for, let's say, a spill or performing a Braden head test. But this list is just looking at essentially construction of a pad, drilling operations, completion operations, and then ultimately plugging and abandonment of the site. So again, looking at DJ Basin first, we have different phases of development here, a low end of a range and a high end of a range. So this was, again, gathered from staff, and they were leaning a little bit on industry to try and get some of these numbers out today. So there are certainly situations where, let's say, pad construction maybe goes quick. It's a small pad and they're done in a week. So there will be outliers from these ranges. The next column over gives you an indication of the timing of notices. So most of these come off of our Form 42. And when that gets submitted by the operator, the 42 goes to our inspection staff and some of our other staff, depending on the type of the form or type of notice. And then it also automatically would go to the other list of recipients that are shown over on the notice type and comments column. So just starting at the top, seismic operations would normally get done in about a week. But if we're talking about a very large survey area, sometimes those may go on for months. The immediate impact would be mostly for the person or persons that are near the operation. So if the fiber-sized truck is closer to you, obviously there may be more of an impact compared to further away. So keep that in mind. For the pad construction, this includes mobilization and demobilization. So getting all the equipment set up and taken down after they're done with the work. For drilling, depending on the operator and the area of the state, they may or may not have a different rig setting conductor pipe or spudding the surface hole. So that may be a different operation. If that's the case, then we would have another notice for move-in rig up. So that would be with the larger drilling rig. And for DJ operations for a 2-mile horizontal lateral, what we're looking at is probably about 7 to 10 days just for the drilling. And then that rig would rig down and move out. So there may be a drilled uncompleted wells, DUC, or as they're defined in our rules, a waiting on completion well. If the operator demobilizes and then waits for a while before completion operations occur, there may be a delay in operations. So at that point, there will be no heavy equipment on the location. Hydraulic fracture treatment for most DJ horizontal wells would be on the order of about 7 to 10 days. For subsequent operations, often it's a quick, get the rig up, perform the work, and then rig down. I left it blank on the high range though, because depending on the well problems, they may have a rig on there for a while. Plugging usually gets done within about a week. And same thing for abandoning flow lines. If it's a larger production facility, sometimes that takes longer. If you got lots of wells coming in for like a central separation facility. And then finally, we have decommissioning equipment and final reclamation. That would be just kind of the initial portion of that. Reclamation does require long-term and ongoing maintenance and monitoring. And next slide, please. And that is not showing up over here. There we go. So PIANT's very similar. The biggest difference is really with the drilling time for drilling the well. And that can vary quite a bit from about 3 days for shallower wells around 6,000 feet deep to maybe 12 days for wells that are around 10,000 feet deep. So that would be up on their own plateau versus down in the valley is really what it comes down to. Pad construction on the west slope could also take a longer time. And a lot of that has to do with construction of the roads and cut and fill. So they're digging into the hillside and then also potentially bringing in aggregate for fill if they need to build up a portion of the pad some more. And I'd be happy to take any questions on these slides.
Commissioners, Commissioner Najapa.
Thank you, Mr. Chair. Thank you so much, Mr. Andrews. This is really helpful. And I'm still kind of digesting all the info. I'm assuming we'll get a copy of this afterwards. But the one question that I had, which was something that I sort of had mentioned before. So I know that in most cases, it looks like the notice prior to the operation commencing is a couple of days. is there an opportunity for those entities who are noticed to raise a concern or to request a delay, or, you know, that type of action? Is that part of the notice process, or is it simply to say, hey, this is happening, just FYI?
It is simply a notice, and Director Murphy or others might expand on this, but you know, as we've gone through the last couple of weeks, there's other opportunities for comment as the permits are going through while before the work's performed.
If I may, Mr. Chair.
Yes, Mr. Meyer.
That will be the subject of my presentation that will come right now, unless there are other questions for Mr. Andrews.
I had one other follow-up question, and then I'll touch base with you, Messner. If we could go back to the DJ Basin. So in this is probably evident, just want to make sure everybody's aware of it. So these time frames, these ranges are for a particular well. The DJ Basin generally has multiple wells on a site, and so the pad construction may accommodate the multiple wells on a site, but the drilling and the hydraulic fracturing treatment, that's like times 20, right, Mr. Andrews? Because they're doing it for each well.
Thank you, Chairman Robbins. That is correct. So the activities that would be, you know, for the entire site, like construct the pad, that would be a one-time thing on this table, but drilling the rig would be per well, or the drilling rig and also hydraulic fracture treatment.
Okay, just wanted to get that clarification out there. Commissioner Messner.
That was my point as well.
Great minds. Other questions for Mr. Andrews? Otherwise, we will move toward Mr. Minor, I believe is next. Is that right, Director Murphy?
Mr. Chair?
Yes. Oh, Commissioner McGowan. Sorry, I didn't see you.
It's okay. This is probably not significant, but I just thought I would double check. I assume that we don't get complaints after everything's all said and done and the tanks are sitting on their pad and they're painted to match, slightly match their background. We don't get complaints about noise or odors at those points. And so, but because those things last for years. Is that an accurate statement?
Mr. Leonard, is he in the house?
Yes, I am. Thank you. No, that's not an accurate statement. We do get production complaints for various reasons. We do get noise complaints. As I mentioned before, there's times when the equipment may not be performing properly. We get complaints when mufflers fall off of engines on pumping units and things like that. Okay. We don't get as many complaints during the production phase as we do during the pre-production phase.
Thank you. I understand that we're looking at this chart based on notification and who gets noticed and how far in advance, but I think it's also informative for the nuisance complaints and what kinds of things are happening within what timeframes and how that might affect folks who are living in proximity.
Commissioner, if I may.
Director Murphy.
Thank you. Yes, Commissioner, I think that we've tried to build out this information in response to some of the dialogue today around when does notice goes out, who does it go to, what operations does it relate to, and how long do those operations last? And we put it together with some really quick feedback from some industry folks about how long it's taking them on average. And so it's probably not the most cogent piece of information we put together, but we did it in a couple of hours to try to help frame exactly your question. How long is a drill rig on site? How long is hydraulic fracturing occurring? And trying to distinguish between the two basins because they are pretty different experiences.
Thank you, Director Murphy. Other questions before we move on to Mr. Minor? Okay, I don't think I'm seeing any. Mr. Minor.
Thank you, Mr. Chair. So I'm going to take a few minutes to provide some additional context for how the proposed 400 series rules as well as the 300 series rules address subsequent operations, changes at existing oil and gas wells and locations, and then also add a little more detail to Mr. Andrews' presentation about how local governments and community members receive notice about those changes and subsequent operations. And it is important to note that the 400 series notices that I'll be discussing are in addition to the notices that we discussed in the 300 and 500 series. So in general, the notices in the 300 and 500 series cover notices of permit applications. And the notices in the 400 series cover things about what's actually happening on the ground at permitted locations and wells. So I'll begin by discussing the interplay between the 300 series rules and the Form 4 sundry notices that are governed by Rule 404, which you heard about from Ms. Stanzik yesterday. Rule 404 requires operators to submit sundry notices to obtain the director's approval for a wide range of changes in types of operations at oil and gas locations. So as Ms. Stanzik mentioned, staff processes thousands of Form 4s every year. And these Form 4s address a wide variety of topics, from changing a contact phone number on a form in the Commission's database to requesting permission to make more substantive changes at a location. So those substantive changes are where the interplay happens with the 300 series rules. So Rule 301C governs changes to an approved oil and gas development plan, and it requires operators to provide specific information about changes to any approved oil and gas development plan on a Form 4. Rule 301C1 requires that the Form 4 be posted on the Commission's website for at least 14 days before staff approves or denies the request, in order to ensure that the public does have adequate notice of the proposed change. Changes that are significant will require approval by you, the Commission itself, and significant changes that implicate environmental protections or wildlife may also require consultation with CDPHE or Colorado Parks and Wildlife under Rule 301C2B and C. If the director does determine that a change is not significant and staff approves that requested change, then the notice of that director approved change will be posted on the Commission's website pursuant to Rule 301C5. A similar standard applies to any significant changes to the design and operation of an oil and gas location that's subject to an approved Form 2A, and that's under Rule 304A3. And any significant change to the area of surface disturbance or major changes like adding a new well or a pit to a site would require submission of a new Form 2A, and the full process involved with staff review and commissioner approval that we discussed during the 300 series. Of course, not all subsequent operations at an oil and gas location involve changes to an approved permit. So many are contemplated by the permit itself, and they are well within the scope of activities approved on the permit. These are what are often referred to as subsequent operations, and they range from more significant activities that might involve bringing a workover rig to a well to less significant activities like routine maintenance to repair a leaky valve. So as Mr. Andrews mentioned a few minutes ago, and as Mr. Leonard discussed in more detail yesterday, Rule 405 requires operators to provide notice to staff, and in many cases a local government, of certain categories of these subsequent operations by submitting a Form 42. So on this slide, I have listed the types of Form 42s that require notice to local governments. And in general, staff has proposed to require that local governments receive notice for subsequent operations that may have surface impacts, whereas only staff receives notice of subsequent operations that involve subsurface operations, like conducting mechanical integrity tests and remedial cementing operations. I should note that staff did not propose many changes to Rule 405 in mission change rulemaking, and that is in large part because several of these provisions were modified very recently in the wellbore integrity rulemaking, as well as the flow line rulemaking. Rule 405 is not the only 400 series rule that requires operators to provide notice of subsequent operations. So Rule 412 governs surface owner notice, and it requires that both surface owners and local governments receive 30 days notice before drilling a well and 7 days notice before other subsequent operations that involve heavy equipment. Staff proposed relatively few edits to Rule 412A, which is prior or current Rule 305F in the mission change rulemaking. However, staff did propose more extensive changes to Rule 412B, which is the move-in or rig up or MIRU notice for short. So under Rule 412B, nearby residents must receive notice between 30 and 90 days before a drilling rig is moved on site Staff has proposed expanding that rule to cover tenants who are not covered in the current rule, and also expanded the radius of the notice to 2,000 feet from the working pad surface. So in addition to the notice provisions I discussed, staff's proposed draft rules also add 2 substantive standards to ensure that subsequent operations at existing oil and gas wells and existing oil and gas locations comply with the Oil and Gas Conservation Act, all of the Commission's rules, and protect public health, safety, welfare, the environment, and wildlife resources. First, as Mr. Andrews discussed last week, proposed Rule 312 adds a new substantive standards requiring staff review of subsequent operations that involve heavy equipment. That's essentially anything that goes just beyond routine maintenance. Under Rule 312, operators must submit a Form 4 for substantive operations, subsequent operations, which staff then reviews and adds any necessary and reasonable conditions of approval to ensure that there are adequate safeguards for public health, safety, welfare, the environment, and wildlife resources. And then second, there is a proposed change that staff made in the 400 series that we actually did not discuss during the staff presentations because it's relatively minor, but it does relate to this topic. So I just wanted to bring it to your attention, and that's a change in Rule 435. So staff proposed to add some new subparts, Rule 435A1 and 2, which require the same public health, safety, and welfare review as Rule 312 for proposed plugging and abandonment of an existing well. That's sort of a similar operation that might bring in a rig or other heavy equipment to the site, but is covered by a Form 6 rather than a Form 4. So staff made sure that the same opportunity to review that subsequent operation and attach any necessary conditions of approval also applied to that plugging and abandonment operation. So that is all I have. And if there are no questions for me, I can turn it over to Mr. Leonard.
Commissioners, are there any questions for Attorney General Minor? Seeing none. Okay, I was ensuring that Priya's movement toward her laptop was not an actual question, does not appear to be one. We will turn it over to Mr. Leonard.
Thank you, Mr. Chair. And Commissioner McGowan, I guess I should clarify the reason I know about the complaints that come in is I do now, and I have for several years, I see every complaint that comes into the commission. So I do get a chance to review all of those and see what they are. At times I've actually mapped out complaints, and when we start getting a larger number of complaints in an area, we want to look and see what we can do to mitigate that. So with that, nuisance issues, they're not something new to the commission. When I came here 14 years ago, we were dealing with the same things: trash, dust, odor, lights, everything you've seen over the past couple of days. And we really do understand that it really impacts people's lives. Probably 99% of the complaints that come in for these nuisance issues, the inspection staff is the first to investigate. And they really do prioritize these. We want to contact the complainant within 24 hours in some way, shape, or form. And we've had staff, walking, driving, sitting in the neighborhoods, eating their lunch in the neighborhoods. And we've been even out in the middle of the night taking sound surveys and everything else to try and identify these issues. We spend a great deal of time trying to lower these nuisance issues, even when limits haven't been exceeded. Back in 2016, there was some issues with noise, and the commission and industry got together in a stakeholder group and developed a toolbox of best management practices to address noise. And many of these practices are still used today, and some of them, they've even been improved upon from then. And this is for levels that were already below what our rules are now. In my presentation, I showed you an example of an odor issue that we couldn't identify, and the director managed to work it out on a voluntary basis. Through testimony over the past couple of days, especially in the area of noise, you've heard conflicting ideas of what noise levels should be. We do recognize those conflicts and the reason behind them. You've also seen conflicting studies and data. I guarantee you we've reviewed many of these studies, and we've tried to incorporate those findings along with our field experience and knowledge into a rule that we feel is protective. And another item, and Mr. Neslin did mention it here earlier, I think it's been somewhat glossed over, is that ability for the director to lessen or increase limits based on an educated consultation and review. There were some stakeholders that suggested that the commission develop a work group regarding lighting, and staff agrees upon adoption of a rule that the work group should be enjoined to develop guidance. And as a note to you, Chairman Robbins, I did reach out to Ms. Smith from Fort Collins. Haven't really had a lot of time to interact though.
Okay.
And with that, I'll take any questions.
Thank you, Mr. Leonard, and thank you for that reach out. And I think the work group around guidance documents around the lighting makes a lot of sense. Director Murphy, did you have anything to add?
Yes, I'd just like to kind of wrap it all together and say that we've been through a lot of different issues today and yesterday in the 400 series that are very technical and very focused, and staff will be here all day tomorrow to help you work through and those technical questions and those precise technical pieces, trying to figure out how to best distill down staff's initial presentation in response to party presentations was a little bit beyond what I wanted to do today, but I want you to know that we're here to answer those questions tomorrow.
That is comforting, and of course we knew you would be here, but I appreciate that. I was going to sort of go on the record by saying something similar, is that, you know, this series is really technical, and when, you know, one stakeholder says technically you got to do it in X fashion and you can't do it in Y fashion, and another one says technically you got to do it in Y fashion and not X fashion, I'm going to want to hear from staff. You know, I think that having just heard from Mr. Leonard, you know, staff's analysis and approach on noise is guided by their multi-decade involvement with this. And that is super critical to help us land the technical 400 series correctly. We got a lot of stakeholders saying it this way and this way, and I'm interested in staff sort of helping us massage through some of those things. So I hate to have staff listen into the discussion and debate, but I think tomorrow is more important than some of the other deliberations. Director Murphy?
Doing the work of this commission is absolutely critical, and it's our number one job. And making sure this commission gets it right for Colorado is what we're here to do.
Other questions, comments, thoughts from commissioners? Okay, seeing none, then I think we have developed our path forward. We will look for a motion to adjourn until September 3rd at 9 a.m. And then we will all have the rest of the afternoon, it's not a ton of additional time, to go over our notes, get our thoughts to you, Ms. Murphy, and then we can start tomorrow looking at the issue list, see if we've got it right. Folks can comment about, you know, that one I really like, and that one it's not an issue for me, and sort of, you know, get some attribution to the list. And then we will tally-ho into the 400 deliberation. All right, so with that, I look for a motion to adjourn until September 3rd at 9 a.m.
Motion to adjourn until September 3rd at 9 a.m.
Second.
See, Kyle, you can teach old dogs. All those in favor signify by saying aye.
Aye.
Aye. Any opposed? We're adjourned, folks. See you tomorrow morning. Thanks for being with us today.